go present a bill in Ways and Means, and several others have too, and then some be coming in and out. So we're going to go ahead and get started. This is a full committee on insurance, and we'll be looking at House Bill 1066. I think it's LC 256320S. Am I correct? Okay. All right. Since this is kind of short notice, we will have a brief public hearing on this. So, but we'll keep you posted if we have another meeting scheduled before. Well, it'll have to be tomorrow at the latest. Okay, Ms. Taylor.
Thank you, Mr. Chairman, members of the committee. Today I bring to you House Bill 1066, substitute number LC 256320S. This is an insurance bill, and it applies only to the self-funded state employee benefit program. This bill is necessary to clarify conflicting language under the plan. This bill is very short and limited in length and scope. Therefore, with the permission of the chairman, I would like to read the bill.
Go ahead.
To amend Article 1, Chapter 18 of Title 45 of the Official Code of Georgia anointed relating to public employees insurance and benefit plans, so as to change certain provisions relating to expenses not to be covered by the state health benefit plan, to repeal conflicting laws, and for other purposes. Be it enacted by the General Assembly of Georgia, Section 1, Article 1 of Chapter 18, Title 45 of the Official Code of Georgia anointed relating to public employees insurance and benefit plans. Is it amended by revising Code Section 45-18-4 relating to expenses not to be covered by the state benefit plan as follows. 45-18-4. The health insurance plan shall not include expenses incurred by or on account of an individual prior to the effective date of the plan, expenses for services received for injury or sickness due to war or any act of war, whether declared or undeclared, which war or act of war shall have occurred after the effective date of this plan, expenses for which the individual is not required to make payment, expenses to the extent of benefits provided under any employer's group plan other than this plan in which the state participates in the cost thereof, expenses for abortion services except in the case of medical emergency, and such other expenses as may be excluded by regulations of the board. For purposes of this code section, the term abortion and medical emergency shall have the same meanings as provided in Code Section 31-9A-2. Thank you, Mr. Chairman. By way of explanation, I would like to state that this plan does not cover elective or non-emergency unnecessary services. It doesn't matter what the service is for. If it's not medically necessary, it's not going to be covered. There has been some questions about the wording that's currently out there, and it needed to be codified. This bill is limited to and applies only to the state health plan. It does not change current plan coverage. It is only to clarify and make sure that people are understanding that if it's an elective procedure, it's not covered. I'd like to state emphatically that this is not an abortion bill. I've heard people discuss it. It is not. The plan does not cover non-emergency, anything that is elective that you choose to have. It would be no different if you were choosing to have a plastic surgery. It's not covered. It doesn't really matter. If it's medically necessary, the plan covers it. That's the purpose of the state's health plan. Do I have any questions?
One comment. I think this is put in place in order to codify what the state health benefit plan is they're currently following. Am I correct?
This is correct. There was some question, and this is to clarify and make it, this is what is currently being done. This is not a change at all. They just needed to be clarified and codified.
Okay. Ms. Hughley?
Mr. Chairman, to the author of the bill, can you shed some light on what kind of problems or what kind of incidences or what happened to precipitate us having to do this?
I believe there was wording in previous laws and bills and things that had been out there where certain times when it is medically necessary, we can get into the details of it, but if you have a missed abortion, you need to have it completed. If you have a miscarriage, you may need a DNC. The current wording may not allow that. This has to be included to make sure you can cover those type of medically necessary services.
The second question is the term abortion and medically necessary. What are the meanings in 31(9)(a)(2)? I just don't know off the top of my head what those meanings are.
Counsel, could you share that, please?
Okay.
Turn your mic. What's your mic number?
You can just give me a condensed version of what it means.
We love long definitions on this one, and it goes on for several lines. So basically, I'll read fast. Abortion means the use of prescription of any instrument, medicine, drug, or any other substance or device with the intent to terminate the pregnancy of a female known to be pregnant. The term abortion shall not include the use of prescription of any instrument, medicine, drug, or any other substance or device employed solely to increase the probability of a live birth, to preserve the life or health of the child after live birth, or to remove a dead unborn child who died as a result of a spontaneous abortion. The term abortion also shall not include the prescription or use of contraceptives. And then under medical emergency means any condition which in reasonable medical judgment so complicates the medical condition of a pregnant female as to necessitate the immediate abortion of her pregnancy to avert her death, or for which a delay will create serious risk of substantial or irreversible impairment of a major bodily function of the pregnant woman or death of the unborn child. No such condition shall be deemed to exist if it is based on a diagnosis or claim of a mental or emotional condition of the pregnant woman, or that the pregnant woman will purposely engage in conduct which she intends to result in her death or in substantial and irreversible physical impairment of a major bodily function.
Thank you.
So what you're saying is this law will not cover elective abortion.
It's elective. The key word here is elective.
So that,
A woman can choose to do whatever they want to. This health care plan has never covered abortions that you just choose to do. When you medically need it, it's what your insurance purpose is, to provide coverage for medically necessary treatment.
Because an elective abortion to me, and correct me if I'm wrong, is mom's okay, baby's okay, or embryo is okay. That would be,
I'm not a doctor, but yeah, that would be, you just choose. That's what I would say, medically necessary. If you just choose, you're pregnant and you don't want to have it, just like I'm getting old, I need a facelift, I choose to have it. I don't expect the health plan to pay for that. That's an elective procedure. There's many things that you can do that the health plan won't pay if it's an elective service.
Mr. Maxwell, are you satisfied?
I do have another question.
Okay.
Now, why are we having to bring this legislation forward? You said it's because of the way our health plan
There was problems with the department that needed clarification. When you're adjudicating claims and administering a program, that's what I do for a living. You have to have it in writing. And this is what it is. There was a gray area where someone could say, what if you had a miscarriage or a missed abortion? You need to have that fixed. It means it's spontaneous abortion, but it didn't completely take care of itself. You then have to go in and have surgical treatment to remove the dead fetus. You want to make sure those type of things are covered. You don't want any hesitancy. That's a medically necessary service. But because it had the word abortion in it, people think, well, you can't have it covered. When it's medically necessary, you do have it. And this is to clarify it and put it in official words that, yes, we cover it as long as it's not an elective procedure. And it goes along with the rest of the plan. Elective procedure is the key here.
That's my question. The plan, I mean, we've had another plan for over 10 years. We've got a new plan that's covering state employees. The plan itself, whatever our policy limits coverage specify,
That's what is right. I think there's been wording in legislation that had been passed in the past that never caught up to your plan document. You have the same plan. You are self-insured. You don't buy a policy off the shelf from someone. You hired Blue Cross to administer what you have. You had conflicting words in that document compared to what your law is. Thank you.
Okay. All right. Okay, Ms. Hughley.
I just want one final question to the author. So am I clearly understanding that we're not asking our female state employees to carry non-viable fetuses to term?
You are absolutely 100% correct. If it's a non-viable fetus and it's medically necessary to remove it, we expect the health plan to cover medical treatment for their conditions. I don't know your definition. This is up to the doctors. The doctors will determine what's medically necessary, what is the treatment that that patient needs. This is where the medical necessity and the emergency treatment, this is where it comes in. It's a doctor decision.
Is that it? Okay. Number 6.
Thank you, Mr. Chairman. I apologize for getting here late, but I don't see anything about rape and abortion. Does that come under
This
rape
is
and
an abortion
incest?
bill. It's medical
rape,
treatment.
I said rape and incest. I apologize.
Okay.
Abortion.
It
Rape and incest.
doesn't even enter into this. This has to do with medical treatment. If a doctor deems that you need an abortion for emergency treatment, this is the way it says, expenses for abortion services are not covered unless it's a medical emergency, and then it's covered. So it will be deemed by what your doctor determines as a medical emergency.
But the question I'm asking, a medical emergency could be a lot of things, okay?
That's correct.
And
That will be.
my question is, if rape and incest come into play, does that constitute an emergency as far as this policy is concerned? That's the question I want to know.
It will go by the definitions that the council read to us. It will be up to be determined by the doctor, medical necessity. If you want to repeat those.
Yeah, can I get a clarification from council?
It doesn't mention rape or incest.
It's not mentioned. It has to do with the determination at the doctor.
So if a woman got raped and became pregnant, then she'd have to carry it. If it don't come under medical emergency.
She may have to. I don't know the circumstances and the outcome of her whole pregnancy. I don't know. I can't tell you other than just because of that issue, can you go have an abortion? No. It will be depending on the medical condition of the mother or the patient at that time. It'll be up to what is deemed by a doctor as a medical emergency. It's not good. It's not clearly. There's not when you. I'm just telling you that's the way. It's not coded anywhere in statute to be able to put that in. It's up to your doctor when he determines medical necessity.
Okay, let me ask one more question. Okay, up until this time when we all employed by the state as state health benefits. Mm-hmm. How many situations where we had where someone tried to get elective abortions with the plan?
There have been requests, and that's why this is being.
But how many?
I don't have a number, but it has come up.
How many?
I don't have a
1, 2,
number.
3?
I have no idea. I don't know.
We're filing a bill. We're going to change the whole health care.
No, we're not changing anything. This is.
Excuse me. I'm just asking a question. I'm trying to get clarification, okay? Mm-hmm. I haven't taken a position one way or the other on it yet, okay? My question is, we're changing the whole law based on what we assume might happen. Am I correct?
No, we're not changing a law.
Okay, so-
This is existing law. This is what is currently there. We are correcting words to codify what is already being done. This is not a change. This is, okay? It's not really changing it.
Yeah, this is just to codify what the state health benefit plan is currently doing. Okay, any other questions from committee members? Oh, okay, go ahead.
This is a hearing. Is it not possible for the board to create rules and regulations in the absence of this?
They have, and there had been a question about them. That's why we are codifying, to clarify it for them. This is the program that they've been basing their plan document on. This is what they've been paying by based on this wording. This is what it's been based on. It doesn't cover it now. It goes back to the elective. When you make an elective decision when it's not medically necessary, it's not covered.
So what does their rule currently say?
It says elective services are not covered. I don't have a copy of the current wording in the document. I don't have it with me. But it tells you it's not covered. That is the handout that goes to the employees, your booklet. But there had been a question about it because we've had legal wording changes in bills, and this needed to match what we're doing. That's basically why we're doing this.
Any other questions from committee members? Do we have anyone who'd like to speak on the bill? Yes, ma'am.
Good afternoon, everyone. And since we're just looking at the bill, I'm Dawn Randolph, representing Feminist Women's Health Center. And we're just trying to understand, since I don't have the alternative in front of me and just heard the representative talk about it's referring to the definition in 31-9A-2. Just want to clarify, in that term of abortion, it says the term abortion also shall not include the prescription or use of contraceptives. So are we now prohibiting contraceptives in the state health blended foot plan? Again, just trying to understand what the intent is. Thank you.
No, it does not change that. The plan has not addressed anything to do with changing prescription drugs.
Anyone else like to speak on? Yes, ma'am.
I'll be brief. My name is Pat Coda. I represent the OBGYNs in the state of Georgia. Georgia ranks 50th in maternal mortality. Georgia ranks 41st out of the 50 states in the rates of teen pregnancy, and we're 4th highest in repeat teen pregnancy in the United States. We rank 45th out of the 50 states in the highest number of low birth weight babies born, and we rank 42nd out of the 50 states in premature births. We have a lot of problems for women in the state of Georgia, and there's a lot of things that we need to do. And this society stands ready to work with any of you and all of you when this body is ready to address the issues that are affecting the women health care in this state. Thank you.
Does anyone else want to speak on the bill? Okay. Introduce who you are and
Mr. Chairman, ladies and gentlemen of the committee, my name is John Walraven. I represent Georgia's reproductive endocrinologists. And I am here today to address House Bill 1066. This bill, you will be presented an amendment to it that is being that has been signed by Chairman Jacobs, Chairman Wilkinson, and Chairman Rogers. And the purpose of this amendment is to restore exceptions for a pregnant woman who is a victim of rape or incest. They should not be denied coverage for an abortion simply because they're not sick. We just appeal to your merciful side. This is a really touchy subject. Nobody wants to come into committee and talk about rape and incest, but we're 50th out of 50 in maternal mortality, and I just don't think it'll help things. This amendment is pretty straightforward. Well, it was pretty straightforward, but this is the 4th version of the bill this afternoon that we've been handed. So the actual wording of it is somewhat out of order, but I'm sure that Legislative Council can help meld the amendment with the new substitute, the 6320S. And I've handed the committee aide some language I think that would accomplish the author's intent. Again, thank you very much for allowing me to speak before you, and I'll take any questions if you have any.
does anyone on the committee have a question? Number 2. Identify who you are.
Thank you, Mr. Chairman. And John, I don't know if this will help or hurt. But my question is, and Darlene, it may be more towards you. As far as the health plan is concerned, if someone is in an automobile accident or needs medical attention through no fault of their own, is that covered under the under the health benefit plan?
Does a medical emergency.
Obviously, it is, depending on accidental injuries are covered.
Like they break a
Accidental-
leg or an arm, fall off a ladder?
Right, yes. If you need, I was thinking of things that are excluded, for example, plastic surgery, if you are cut, yes, things like that are
Elective
covered.
things.
That it no longer becomes elective because it's tied to a medical condition and therefore it is covered. But it's tied to a medical condition.
Okay, and the medical condition, though, was
It's a broken leg or it's
Okay.
lacerations of the face or whatever the condition is. It's tied to that and that's why it's covered.
but it was a condition that unanticipated by the patient.
That's correct. If they had an accidental injury, yes.
Gotcha. And John, and this is the question to you. In the case of a forcible rape or forcible incest, that would be something unintended by the victim or by the patient. And I assume that's the intent of what the amendment that you're trying to bring.
Absolutely, Representative. And in addition, in January, the United States House passed a almost identical piece of legislation as to this, but they had an exception for acts of rape and incest. And we would just ask that Georgia not be insensitive to the victims of these crimes.
Thank you. Thank you, Mr. Chairman.
Any other questions?
I got one.
Okay.
Number 11. John, I have a question for you, sir.
Yes, sir.
You mentioned in your statement there that you're putting it back in the plan so it would be covered. So I'm assuming that you're saying sometime in the past that was coverage that was afforded. You said in your opening statement that this amendment would put it back into coverage.
No, that is not what I meant to communicate. I'm sorry. What I meant when I say put it back is that historically, Georgians have had exceptions in the law up until a couple of years ago, where victims of rape and incest were essentially left to themselves to heal and move on. And whether or not the state health plan paid for their procedures is a question for probably somebody else. I'm sorry.
Well, okay, I was.
Yeah,
I thought you had said. I thought you
answer.
had said that historically, or that we put it back in because this is dealing with the state health benefit plan. And my question was, this has been covered in the past. Sometimes it hasn't been. Okay, that's you want to add that coverage into the plan then.
Or to accept it from the exclusion.
Right.
Yeah, yes, sir.
Okay, thank you.
Representative Hughley.
Thank you, Mr. Chairman. Can we have the wording that you're suggesting? Can we take a look at what he's suggesting?
Yeah, let me see. So I just want to remind everyone that this is just a hearing, and we're not going to be taking any votes, so there won't be any amendments offered today. So this is just a hearing only, so any of these ideas you're welcome to share. And anyone that would like to testify on this bill is welcome today also, because if we hold this in full committee, this will be your chance to do so today. Any other questions from the committee? And is there anyone else that would like to testify? Okay, we've got a couple more. Come on up.
Thank you, Mr. Chairman and committee. My name is Mike Griffin. I am the lobbyist for Georgia Right to Life and also for the Georgia Baptist Convention. We'd like to speak in favor of this bill, and we certainly appreciate everything that the governor has done over the summer in correcting the state insurance plan and encouraging the board to make changes, because up till this day, taxpayers were a part of funding about 75% of this plan that offered this type of procedure. And in the 9 years, I believe it is, since we've been passing legislation that has anything to do with abortions, there has not been a single bill passed that has rape or incest exceptions in it, including the fetal pain bill did not. So that has not been the practice of this legislature in recent years, just for the record. And so we would ask that it not be added into this one. We think it's a very good bill. It's throughout the years, citizens in the state as well as our nation have not been in favor of taxpayer funding of abortions. And in the state of Georgia, we've not been in favor of any exception for the life of the mother other than, the life of the mother as well as medical emergencies. We've allowed for that. Thank you, Mr. Chairman.
Okay. Are there any questions from the committee? I don't see any, Mike. Thank you. Yes, ma'am. Come on up.
Thank you, Mr. Chairman and members of the committee. My name is Mary Boyard. I am the Respect Life Director for the Archdiocese of Atlanta. And I just want to say that we support this bill, and we appreciate the efforts that you're making to put this into law to clarify the questions that have been raised. And we would also support not adding the amendment for rape and incest, because we understand that's a very sensitive issue. But the child who is the result of that should not be the victim as well. And that would be our position, that we would not support any legislation that would authorize the killing of a child that could have been the result of a terrible tragedy such as rape and incest. Thank you.
Okay. Thank you, ma'am. Is there anyone else that would like to testify to be heard on this bill? Okay. Any other questions from the committee? Representative Taylor, do you want to
I'd like to make a few
up?
closing remarks.
Please.
I want to go back to what I said in the very beginning. This is an insurance bill. People are making this an abortion bill. It is not an abortion bill. The state health plan has never paid for elective procedures, elective abortions. If this is something that the committee decides they want to cover, we're going to need a fiscal note to find out the numbers that are involved, and it's a major plan. We all know we have just gone through a lot of upheaval with our health plan, and this is not intended to reopen the health plan. It's something that could be considered at some point in time, but I have to tell you, this is an insurance bill. It's not an abortion bill. It has to do with how the government manages its own employees' health plan. This is considered an elective procedure, and that's the portion that should not be covered. I ask for your favorable consideration. Thank you, Mr. Chairman, members.
Representative Taylor,
Sure.
would you like to just say anything on the amendment?
No, I don't particularly like this amendment, and I would not like to add it to my bill.
Okay. Thank you very much.
Thank you.
Well, that'll conclude the hearing, and thanks for everybody for being here today. Y'all have a safe trip home.